Well, thanks for having me. It's really a pleasure and an honor.
Yes.
I'll pass over to Barbara. I think we'll take the lead with the conversation.
Yes. I also wanted to thank you for coming, taking time on your day. And I thought there'd be more people. I think there's enough time for us. We only have 1 hour of your time to go around the room very quickly with just people's names and titles, and then we'll get started with our questions.
Okay.
So I'm sorry.
Want me to begin?
This is PTO Director Andrei Yanko.
Sure.
I'm Malati Nayak. I'm the IP law reporter here.
Kyle Jodner, also IP reporter. Tommy Chen, a data scientist.
Kristen Highland, I'm a deputy editorial director. Rebecca Hoffman, assistant managing editor.
Diane Holt, I'm a managing editor in our corporate and transactional group.
Elizabeth Turkman, I'm acquisitions manager for IP Books.
Angela Gregorits, I'm a managing editor in the editorial section of IP.
Michaela Ross, I'm also a tech and telecom reporter.
Peter Leung, a legal editor. I focus on the patent side of IP.
Ananda Majumdar, I'm a senior legal editor, and I cover mostly copyrights and trademarks.
Barbara Ewell, I'm the news director here.
All right. Alex Butler, I'm Vice President General Manager for many things commercial and Bloomberg Law, including intellectual property.
Josh Eastburn, CEO of Bloomberg Green.
Rebecca Baker, managing editor for IP News.
I'm Chris Shipp. I'm the Chief Communications Officer at the USPTO.
Nice to meet everybody.
Oh, yeah.
It's very impressive. Thank you.
So we'll have a number of questions. The reporters are right around the mic, and we'll move it around the table as we have to. I wanted to start with one quick question, and that is, I'm wondering how your background as a litigator and a managing partner at a large law firm prepared you to lead the PTO.
Yeah, so, the patent system, the IP system, but patents in particular, I think over time has been pushed and pulled in different directions, and some folks think at times that it's too much pro-tech or too much pro-bio or pharma, too much pro-patent owner or too much against the patent owner. And I come from a very mixed background. So coming from a private law firm, has exposed me to all of those different areas. I've had clients and opponents from tech to bio and aerospace and everything in between. I've represented plaintiffs, defendants, big company, small company, and so forth. And I think I think that's helpful to some extent to be able to strike the appropriate balance and to have hopefully the right amount of credibility that I don't have a particular horse in the race. And with respect to coming to a very large entity of almost 13,000 people from a significantly smaller entity, but still a major law firm, it still doesn't approach 13,000 people. I think the skill set scales up, because when you deal with, or when you're leading an organization of highly skilled professionals, it is the same issues come up, whether it's a few hundred people or several thousand people. You have to draw out the best from each one of these individuals, listen to everybody, create a team environment, and I think and let folks set folks free to feel like they're free to express their best ideas, because they're all highly skilled. And I think that's the same whether it's a smaller firm or a big agency.
Other than offering guidance to patent examiners, what's been done and what will be done moving forward as well to make patent eligibility more predictable?
Well, there are several ways in which we at the PTO can direct policy. Setting and giving guidance to examiners is the number one approach, because that's what we do. We have more than 8,000 examiners. They interact with the applicants daily, and we issue, we review hundreds of thousands of patent applications a year. So that's the most immediate and most important approach. And by the way, the guidance to examiners is not just for examiners. It is for the applicants, obviously, but it also sets the tone for the entire discussion. We also, at the Patent Trial and Appeal Board, that board issues decisions, lots of decisions every year, so that's another way of disseminating policy. We advocate through our solicitor's office, whether it's at the Federal Circuit or other courts, and we provide views in conjunction with the Solicitor General, the Department of Justice, at the Supreme Court as well. So that is yet another way where we can advocate for policy. Plus public speaking, which I've done some of it, and meetings like this. So those are some of the avenues. On a forward-looking basis, what we've already issued since I've been here, 2 guidance memoranda. I've already spoken publicly on Section 101, patentability, subject matter patentability. But on a going forward basis, we're looking at a broader statement of what we believe the law is, given what the Supreme Court has told us and all the other courts, and given the statutory intent and our deep knowledge and experience in this area. So instead of reacting to every new case that comes out, we're hoping to have some forward-looking positions as to where the lines of patentability should be drawn.
Maybe can you share with us some of the specific sort of positions that you might be taking, some of the specific changes that you would recommend going forward?
On 101,
yes, on
section
yes.
patent. Okay. So sure. So the patent statute was amended in 1952. And obviously has been amended since. But the 1952 Patent Act was critically important in several respects. In one respect, it outlined very specific bases for patent validity or invalidity. So, specifically, if what you need for a patent to issue is for it to be novel under Section 102, to be non-obvious under Section 103, to be adequately disclosed and claimed pursuant to Section 112. So there has been 60 plus years of jurisprudence in each one of those categories. Examiners, applicants, judges generally know how to apply the law in those very specific categories. So a way to think about Section 101 is, if a patent application passes with flying colors in those 3 categories, it is brand new, totally novel, non-obvious, and it's really well claimed and disclosed. So it passes 102, 103, 112 with flying colors. Under what circumstances do we still want to say no patent to that? And I think if we look at the Supreme Court jurisprudence as a whole, the Supreme Court has told us generally when it is that we still don't want to issue a patent, even if the other statutory grounds are met. And I think it would be good to clarify what those specific grounds have been that the Supreme Court has told us. A couple of examples. So I think there's general consensus, the natural phenomena or products of nature. So for example, gravity or blood cells, for example, that exist in the human being naturally and so forth. Those should not be patented even if they're brand new discovered, non-obvious, and they're perfectly well claimed. That's one example. There are some other examples as well. Mathematics as such, just basic mathematics. That's another example that the court has said, no patent, no matter how well, unless there's more. Okay. Fundamental economic principles, hedging, market hedging, for example, or escrow accounts. Supreme Court has told us that those also should not be patented. So I think it's important for us, and what we're trying to do is to try to identify those areas. If you are not in one of those areas, then it is probably better to allow the other statutory grounds to do the work. Put it a different way. Think about abstract ideas. The Supreme Court has also said that abstract ideas are not patentable. But let's look at the other statutory grounds. Let's say that you have something that is totally novel, brand new discovered, non-obvious, and it also is very well disclosed and claimed under 112, such as it is perfectly well enabled. What does that mean, enablement? The enablement requirement under 112 says that the invention has to be so well described that one of skill in the art can actually make it without undue experimentation. That's 112. There's lots of law on that. If you can make something, build it, create it, without undue experimentation, why would it be abstract? And the answer to that is, it would still be abstract if it is in one of the categories that the Supreme Court has said that we don't like, no matter what, such as mathematical formulas. So anyway, so those are just some parameters, the ways of thinking about Section 101, and from those principles, perhaps create guidance that clarifies where the lines should be drawn on a lot of those applications. Sorry for the long answer.
No, that's great. So just a quick follow-up. Would it be fair to say that under that framework, you would look at 101 last? I've heard several people suggesting you should do novelty obvious and send enablement first, and then 101 sort of the last filter. Is that sort of what you're suggesting?
No, not necessarily. It's just a way of thinking for the examiner and the applicant how you approach the analysis. There are other practical considerations to examination. Mm-hmm. You don't want to issue office actions piecemeal. That's a very practical issue because you still want to issue patents. You know, you don't want the pendency rate of patent applications to increase. It's the last thing we want to do at this point. So you don't want to have this back and forth with the examiner, or 102 and 103 and 112, and then only at the very end, let's say that it passes all those things, 2 years later or a year and a half later, you say, oh, great job on that stuff. And thanks for the year and a half back and forth, but by the way, invalid under 101. So we still want to do, I think, all of them together, but the way to think about them is perhaps while you're doing it, think about it with 101 at the end of the process. If you thought to yourself as an examiner that this is perfectly well described pursuant to 112, enabled, not indefinite, then maybe ask yourself, why would you think it is abstract? And again, the answer would still be perhaps if it matches the few categories that the Supreme Court has identified.
That's great, thanks. I know you've been speaking about guidance to the examiners. To sort of step back a bigger picture, do you think these changes can just be made at the PTO or at the courts, or does Congress have to step in on 101?
Look, we are certainly going to try at the PTO. I think we can help improve the matter. I think the 2 guidance memoranda that we already issued, I think those have already improved the status quo a little bit. I think the courts likewise can help in this regard. And I have said before, that neither we at the PTO nor the lower courts should overinterpret what the Supreme Court has said in its Section 101 jurisprudence. And I think if we all use some judicial restraint and stick closely to what the Supreme Court has said, I think we will go a long way towards adding clarity to this area of law. Unless the Supreme Court does something else, do I think that that will be sufficient? I don't know the answer to that. We have to wait and see. Unless the Supreme Court takes another step, is legislation absolutely necessary? Again, I don't know. I think we should try this, what we're doing. I am aware that there are efforts to try to push some legislation in this area. For now, at the PTO, we're just focused on what we can do at the PTO. Any legislation that is tried, I don't know how effective it would be in the end and how long it would take to get there. That doesn't mean that folks shouldn't try if they think it's appropriate. But for now, for us at the PTO, we have a lot of work to do on a daily basis. So we need to focus on what our examiners have to do on every day, today, tomorrow, and so on.
And just one more quick follow-up question to this. You mentioned you're hoping that the courts, they interpret the Supreme Court, the lower courts, they interpret the Supreme Court judiciously. They'll be able to, bring some clarity. Do you think the Federal Circuit has done that in the last sort of 5 years of 101 rulings, applying the two-step test? Do you think it's clearer now? Has that been helpful, you think?
Well, I think the state of the law now, given the entire body of law from the Supreme Court and the rest, and as applied by the Federal Circuit and the lower courts, just the entire body of law has created the situation we are in now, which where the lines are somewhat murky. And the Patent Office itself trying to apply what we learned from the courts likewise. Just the whole system as a whole, I think, has resulted in increased or a decreased level of clarity.
Okay, well, I don't want to dominate the questioning.
I wanted to touch base with you to talk a little bit about trademarks. You talked a little bit about patents, so let's switch gears a little bit and talk about trademarks a bit. Tell me about the trademark-related initiatives you have for the PTO.
So the trademark operation, let me just begin by saying it is in very good shape overall. Our pendency rate is low, our quality is high, and by and large, our stakeholders are quite happy with the work we do in the trademark office. There are certain issues that we are addressing. I'll just give you a couple of examples. We have, in the past several years, we have seen a huge increase in applications from China. A lot of them potentially fraudulent, and it has, the huge increase has put some strain on our operations. We have responded very well to it. We have hired additional folks to address the increase, but nevertheless, the increase has been significant, approximately 1,100% in the past 5 years from China alone. So we are looking at what else we can do in that area to address some of the issues. And it would include things such as perhaps a requirement for a local counsel so that we can keep a better track on the quality of those applications and the like.
Local counsel in China?
No, here in the United States.
Okay.
We're also looking at ways to help declutter our register in an appropriate fashion, where all the rights owners' rights are being respected and the like. So those are some examples. I should mention, it would be a failure if I don't, that at the end of this week we're going to have our Trademark Expo, and we're very much looking forward to that as well.
Follow up quickly on that. Given that there has been a lot of talk in the Trump administration about China and IP theft, and you talked about a 1100% increase in trademark applications and a lot of them being fraudulent, is the administration aware of this? Are any actions being taken, or in terms of what's happening here on the trademark side? Are any discussions on in terms of how you may address this situation?
Well, again, we are part of the administration, so yeah, I mean, we're addressing, we're trying to address this issue in some of the ways I've just mentioned. It is important, and I should say that my understanding is that the U.S. PTO is not the only trademark office that's around the world that's seeing increases of this sort.
So you mentioned decluttering the trademark register, and I assume that's what you're referring to is the trademark registration auditing program?
That's one approach.
So you've been doing that for a while now, I think over a year, is that right, Paul? Mm-hmm. So
Approximately.
What I'm wondering is that at what point will there be some sort of metrics or data released on how many audit letters have been sent out, what the rate of response is, if there have been any cancellations resulting, and whether those metrics will be made available on an ongoing basis to the public?
So I don't know at this time when we would do that. It is important to take stock, though, of where we are. That the audit approach is one way we're looking at decluttering. There are other ways we're looking at decluttering as well, and we have a trial program for expedited challenges as well, voluntary expedited challenges as well. So we do need, and this is one of our initiatives right now or in the next months, in the near future, to further address the clutter.
Okay.
And once we dive deeper into that, we need to see whether these couple of programs that we have are working well enough, or we need to add some other approach.
Okay, I definitely want to follow up with you guys on the whole decluttering thing.
Has the increase in the trademark applications for China, has that been the most difficult operational challenge your office, the trademark office, has faced?
Yes, so that's one of the main ones in recent times and currently, because it affects quite a few things. So, as I said, we want to maintain pendency times and quality, and we have done both of those things. That has required an increased level of hiring of new examining attorneys, for example. That adds the additional operation of having to train folks and integrate them into the system. So it has rippling effects. There are other issues we're very much focused on with respect to trademarks, including the use of technology for the trademark prosecution process and for the registration process. And these dovetail with each other, but the increase in applications, the rapid pace of increase in applications has been the number one issue.
How many more folks have you had to hire to deal with this 1,100% increase?
I don't have the actual numbers. We can definitely send them, though.
Okay. In the past couple of years, there had been some issues relating to monitoring the work of off-site trademark staff. And what is the status of that issue?
And it's not just trademark staff, it is all PTO staff, including patent examiner and the like. And you're talking about folks telecommuting?
Yeah.
Yeah. We're paying very careful attention to that across the agency. Overall, I believe that the program is working well. It has significant benefits to to the agency and the system as a whole. It does add our ability to recruit more broadly, including geographical breadth, which is very important. And it allows for our ability to interact with our stakeholders more broadly across the country. But of course, along with that, we need to manage folks remotely, and I think we've done a very good job with that.
Does the telecommuting program integrate at all with the opening of the new offices in Detroit, Denver, Dallas, and San Jose?
Opening more offices than those,
Right.
or? There are no current plans to open more offices. Having said that, I think those 4 offices, the regional offices, do a phenomenal job, and it's really, really important. And I have already visited 3 of the 4. Just a couple of weeks ago, I was in Denver, and I visited that office. And I think what those offices do, well, first, it provides a base for folks locally there to work from. It provides the ability to have outreach to our employees in the neighboring areas as well. So that's really important from a management point of view and the recruiting point of view. And one of the most important features is it allows for the PTO to interact with stakeholders, inventors, entrepreneurs in areas far away from Washington, D.C. And to me, that is one of the most important things for our growing economy, our ability to incentivize innovation and entrepreneurship in as broad of a geographical and demographic basis as possible.
To what extent do those regional offices play a role on the trademark side as opposed to the patent side?
Equally important. They handle every type of an employee in their regions, whether they're patent or trademark examiners, whether they are trademark appeal judges at the TTAB or patent judges at the PTAB. So they handle all of those folks.
And interactions with applicants and
interactions with applicants, interactions with the community, seminars, for example, on entrepreneurship is one example that can take place in those regional offices. It's, I think all those things are great benefits, both for trademark and patents.
We're going to switch gears a little bit and ask a couple questions about PTAB. Peter, you want to kick us off?
Back to patents.
PTAB, it's
Yeah.
it's a little bit of everything.
Yeah. So as you all know, for the last few years, there's been some criticism from some parts of the stakeholder community that the PTAB is kind of unfair to patent holders and the rule, and some of it because of the way the rules are set up. What do you think of those criticisms? Do you think they're warranted or not warranted? And are there any suggested changes that might be in the works to address those issues?
There are separate issues baked into your question, which is a very good one. There are substantive issues and then questions of perception, and those two dovetail to some extent. But having said that, there's no question there is a perception, or there has been a perception, as you have articulated, that post-grant challenges are slanted or have been slanted against patent owners. Irrespective of the substance and the substantive accuracy of that perception exists, I believe, and we need to address it. Because faith in the system is critically important for the patent system. And if folks don't have faith in the reliability of the system, or the fairness of the system, and the balance of the system, then the innovation ecosystem suffers. So we are looking at all those issues. Give you some examples. So the notice of rulemaking for the claim construction process, which we have just promulgated. The comment period has closed. We've received a large number of comments. But that's one example of a change. So we're looking at the comments as we speak, and we'll decide how to proceed in light of the comments. But that's one example of a proposed change that I think goes towards addressing that balance question. Patent owners have asked, why is it that the same patent is reviewed under a broader standard in the patent office versus in a district court proceeding? 85% of our IPRs have parallel litigation associated with them. So patent owners have asked, why is it that in a PTAB proceeding you can invalidate my patent for scope under which I can never enforce an infringement action, right? So that's a question that I think needs to be addressed, and that's the reason for that proposal. Amendments is another example. The statute, the post-grant, the AIA allows for amendments in post-grant proceedings. The PTO has received criticism from a lot of sectors, including courts, that we haven't allowed significant numbers of amendments or any meaningful number of amendments. So we will make a proposal for a more robust amendment process. And hopefully folks will take advantage of it, but that's going to be up to them. What we can do as the government is provide the system, and hopefully that as a balanced system that folks can take advantage of if they choose. There are other similar examples like that as well.
Just so I can make sure I'm clear. So
Sure.
This is we know it was Aqua Products that changed the burden of proof for the amendments, and so you're saying there's going to be more changes to the way the PTAB handles amendments. Is that?
That's correct.
Can you give us any sense of where that's going, or
Sure.
what we're going to be looking at?
Yeah. So several guidelines for what I think is a robust amendment process. It has to be done during the AIA proceeding itself.
Mm-hmm.
Some folks have talked about an off-ramp, for example.
Oh.
Okay. Whatever the merits would be to an off-ramp,
Mm-hmm.
I don't think is what the AIA statute requires. The AIA statute says you should do it during the process. So I think it has to be done during the AIA process, number one. It needs to be addressed, any amended claim needs to be addressed by the PTAB in the final written decision.
Mm-hmm.
Any amended claim needs to be addressed by the PTAB in the final written decision within the statutory 12 months, unless there are exceptions that can push it out to 18 months. But by default, it should be within the 12 months. It should be an inter-parties process, because AIA proceedings are inter-parties after all. Both sides should have the ability to participate.
Mm-hmm.
And there should be the possibility, if the patent owner so chooses, of at least some level of iteration, such that it's not an all or nothing approach. So those are just some guidelines.
Kyle?
Yeah, I was going to ask about the number of federal circuits' decisions that have overturned PTAB rulings, and I was curious if you had any thoughts on kind of why that is, if there's any common threads that kind of illustrate that, and if so, how you guys are kind of reacting to that.
Well, overall, I think I don't have the actual statistics handy, but I believe that the affirmance rate of PTAB decisions is fairly high. Like with any court, there will be a number of cases that will be that the Federal Circuit will have a different view on. I think there are a couple threads that have emerged over time. One example is, for example, the Federal Circuit in some cases wants to see more a more detailed analysis in the final written decision. In some cases that they have sent back. And I do think that the final written decisions should be fulsome, and hopefully the judges will do that. I do think they do that in most cases. So that's one example.
Gotcha. Is there any subject matter areas that have been particularly common, or any particular types of like obvious prior art, that kind of thing?
I haven't seen a systematic ground on which there has been reversal, but I would need to think about it.
Okay. And as far as the Supreme Court's decision in the SAS case, have you guys seen a shift, either a increase in your workload, or I've seen some places say that it would just kind of shift it from the initiation to the final decision? Has that affected your guys' workload, and have you guys had to adjust to that at all?
Yes, there is no question that there is at least for now, there is an increase in workload. For all the new cases, obviously we are addressing all the new claims and all the claims and all the grounds that are being petitioned. But the main thing that's adding work right now is that we have gone back to all the existing cases. Even on the cases that had partial institutions, we've gone back and added all the other claims, all the other grounds into the proceeding.
Yeah.
So at least for now, that has definitely added
Is that
workload.
going to be kind of a temporary thing? Because the increase of the workload, obviously, they had to spend all the time deciding whether or not to institute these various claims, and now, obviously, the new cases, you don't necessarily have to do that, at least in the institution phase.
So there is no question that there is a localized effect from the existing cases. With the new cases, it's not clear yet what impact that will have, because it could be that petitioners will be more selective in the types of petitions they file and the claims they challenge and the grounds they bring. Because now everybody knows that if we institute at all, we're going to institute on all claims and all grounds, good or bad.
Yeah.
So there are significant consequences to the petitioner now if we institute. But we also institute on the claims and grounds that they're likely to lose on. So that might lead to a different calculus for the petitioners. We just have to wait and see how that plays out. What is for sure, though, is that for all the cases that were already instituted, those didn't necessarily have that thought process up front. So for the existing cases, for sure, there's this increased workload. So we'll see in about a year or so how that whole system goes through. I should say that our judges have done a very good job working hard for the past couple of months to adjust to the new situation.
So in terms of looking at perhaps the need to hire more judges if needed, would you just wait for the shakeout, or do you have any understanding now in terms of whether you need more judges on board to deal with this?
Yeah, we are hiring a few more judges right now. It's not a huge number. It's a fairly small number to deal with the current case workload. For a potentially bigger a wave, we need to wait and see how this plays out.
Speaking of judges, I know one criticism of the PTAP has been what they've been termed panel stacking, about in certain cases where they put more judges, on, and I think it came up briefly. I think Justice Gorsuch mentioned it, I believe, and I forget what oral states or SAS oral arguments. But what are your thoughts on that, on the practice? I believe Chief Judge Rushdie has said that he does that it's rarely done, but it's done to ensure the to get the consistency of the outcome, which some people have taken issue with that excuse me, with that comment. So, what are your thoughts on the practice?
Yeah, the concern had been that panels are enhanced or judges get added to obtain a predetermined result. As the chief judge has, Chief Patent Judge Rushke indicated, that hasn't really happened for sure recently. Sometimes, as he has indicated, panels have been enlarged with the chief judge and the deputy chief judge at the PTO in order to obtain consistency of results between various panels at the PTAB itself. Now, I am aware of the criticism, and I'm aware of the perception, and as I said, we need to deal with that. So we are looking at changing that practice, and we will have potentially a new approach to that. There has to be a mechanism of bringing consistency among the 300 judges and the various panels, both procedurally and substantively, and for setting agency policy. What we want to make sure, though, is that there is full disclosure. Everybody knows exactly what that process is, who those judges would be, and that the parties in a particular case have the ability to comment or participate in any such proceeding. Similar to what most other courts do. At the Federal Circuit, for example, they have an en banc process, likewise to address issues of broader implications and importance. So the issues are somewhat different for us, of course, especially since we have 300 or so judges. But we have to have some process for dealing with those sorts of situations.
I think Molly has a question about emerging technology. And,
Yes, yeah, that would be shifting gears back to 101.
a little bit.
Yes, in terms of emerging areas of technology, there's autonomous vehicles, or you think of blockchain and artificial intelligence. What are some of the new issues or questions that the agency has had to deal with as it weighs patent applications in these up-and-coming areas of technology, and what guidance are you giving examiners when they look at such applications that cover these technologies?
Yeah, so these are some of the reasons why I think we need to address Section 101 sooner than later. These are applications that we're seeing now on a daily basis. Blockchain is one example. Cryptography is another example. Obviously, artificial intelligence is another example where there is a lot of interaction between machine and software code that activates the machine. There's machine learning involved. These are issues that under the current law or body of law for Section 101, many times you don't know whether a particular application is in or out, and applicants, their lawyers, examiners, judges, and so on struggle to figure out whether it's in or out, under 101 only. And even when you think you have an answer, other folks disagree. So it's one of the main motivators, in my mind, for resolving the issue sooner than later.
In the meantime, is there any guidance that you would be looking to provide examiners while they study these applications?
Well, it's the guidance that I've already described. That it's the we've issued a guidance memorandum on the second step of the ALICE test and what it means to be conventional and how to document that. I think that's very important. But more importantly, it's what we're looking to do next vis-a-vis the various principles I mentioned a few minutes ago with respect to what exactly are the areas that the Supreme Court has told us we should stay out of. And how does 101 jive with the existing statutory sections and jurisprudence under 102, 103, and 112? And we're looking to do that sooner than later. We're not talking years here. We're talking in the next few months where that we hopefully can address these issues.
Mm-hmm. I think Ananda has some questions about, in regarding Brunetti, the pending trademark case.
Okay.
Right, I think the PTO recently got an extension to file a petition in that case, and I'm wondering, what stage is it now? Is the PTO on track to file, and are you having second thoughts about going to the Supreme Court on that?
It's still under consideration, and since it's an active case, I can discuss the details. But we will take action one way or another prior to the deadline.
Well, let's assume that the Federal Circuit's Brunetti ruling stands. Under that condition, would the PTO expect any significant increase in registration applications covering scandalous and immoral matter? And if so, are you preparing examiners at all for how to handle that kind of application?
Yeah, we've taken a look at the statistics on that, and we haven't seen a huge number of applications surrounding that. We certainly have seen some, but it's not overwhelming. And I certainly think we can handle the issues no matter how the ultimate result goes.
What's the nature of the PTO's relationship with the White House's intellectual property enforcement coordinator? What seems to be Vishal Amin's priorities, and how is that affecting your office?
The IPEC is focused on enforcement issues and also some other policy considerations. But intellectual property is of broad interest nowadays, not only in government, but in industry as well. There are a lot of entities interested in intellectual property. So what's critically important, really, is that this administration, from the president on down, obviously including the PTO, the IPEC, and other folks, such as at the USTR or the Justice Department, including, for example, the Antitrust Division of the Justice Department. There is a lot of interest in this administration in intellectual property, and folks are well aligned in making sure that we have a reliable and predictable IP system at home, and we do whatever we can to defend the intellectual property rights of our companies abroad.
Actually, could I jump in with a question that might be the spot for it? We had, of course, and you might be, we've heard your answer to this question a few times. We're going to ask it in a little different way. The concern about competition with the U.S.'s ranking from the chamber of being, following in its innovation ranking. And, yes, maybe that might be a little, a few basis marks, but it's still falling. And we're wondering, with the administration's focus on making sure that our innovative economy is keeping up with China's. And in comparison, China's issuing exponentially more patents at a quicker clip. What is the PTO's perspective on that? Is there something to be learned there on a strategic basis, or how are you seeing that difference in the number of patents being issued between the two countries?
Yeah, so we're certainly aware of the number of applications from China on the patent side, also the trademark side, as we've already discussed. We have our eye on that. Our focus from the USPTO is how do we encourage ultimately, the ultimate question is, how do we encourage and protect American innovation and entrepreneurship and more of it? So what I have been focusing on, I think, are critical components that go towards increasing the robustness of our system. So I think in order to increase innovation and entrepreneurship, we need to increase the predictability and reliability of our IP system. We must do whatever we can to broaden our footprint in the United States for innovation and entrepreneurship, to take it across as much of our geography as possible, to take it across as much our demographics as possible. There are a lot of, as they say, lost Einsteins in this country, and I think our country is so innovative. Our overall systems are so good that, and I'm not just talking IP, I'm talking IP, entrepreneurship, the free market system. I think all that is second to none. And I think if we provide the right tools and we create the right environment, we will maintain our leadership in the world.
I think we have time for one more question. I'd like just to throw it open to anyone who hasn't asked a question. If they have something to ask, speak now or hold your peace.
Well, the Office of Policy and International Affairs is of particular interest to me because it's, I think, the only place in the PTO that has a copyright component. And I'm wondering, is there, are there any particular plans for the future of that office? Are there any restructuring in mind?
So, as you probably know, there was a time last year, before I came in, that there was a discussion about restructuring that office. I have said publicly, at least a couple of months ago, I believe, that I believe that office provides important functions to the PTO and to the IP community in general. I don't think there is a need for significant structural changes to that office. Any possible concerns that people had with the interrelationship of that office and the rest of the PTO operations in the past, that can be addressed through closer coordination inside of the office. There's so many important policy issues that office addresses at the intersection of patent, trademark, copyright, trade secret, and the like. Issues of international IP policy, and not to mention the IP attaches that exist around the world that provide tremendous services to stakeholders that do business, American companies that do business around the world, and American government officials that travel around the world and need to know how to operate within the IP ecosystems around the world. So overall, that office is an integral part of the PTO.
Actually, we have time for one more quick question, so we can open it up.
Chris?
What's your favorite animal?
Actually,
I shouldn't have asked him.
I did have one quick question. Yesterday, the Federal Circuit came in the allergen, the whole issue of sovereign immunity
Sure.
and state immunity. The decision was kind of interesting. I wanted to get your take on the decision regarding this ruling on sovereign immunity and the citation or the reference to state immunity. And it seems to be, it kind of came down as an odd decision, not the decision itself, but sort of their reasoning with it. And I kind of wanted to get your sense of where the PTO will go from here in the wake of this.
Well, the decision affirms the PTO's decision on this issue. Irrespective of the reasoning, the decision does say at the end that it applies to the facts before the court in this particular case, which is tribal immunity. and that the question of state immunity in post-grant proceedings is left for another day. So we'll have to see how that jurisprudence develops down the line. The PTO has taken the position in prior decisions that state universities, for example, could have immunity in post-grant proceedings, but in the particular cases that came before us, vis-a-vis the state universities, they had waived that immunity. And we'll see if the Federal Circuit speaks to that issue and when. The decision is also interesting. Yesterday's decision is also interesting that it reaffirms the PTO's broad discretion with respect to the institution decision, which was statutorily created. That and some other issues from the decision are quite interesting.
Very good. Well, thank you so much for your time and for answering all of our questions, our wide-ranging questions.
Yeah.
So,
Thank you for the very interesting discussion. Yep, absolutely.
very much. Please help yourself to some refreshments.
All right.
Here you go.
Not sure how to turn this off, but I guess there is a mute here.